Okay. Then we'll go on the record in file 15 CF 627 entitled State of Wisconsin Plaintiff versus James A. Barker III Defendant. If you state your appearances for the record, please.
Zeke Wiedenfield appears on behalf of the state.
James Barker, appearing for say.
Okay, Mr. Barker's here in person without counsel. And we're here today to continue the motion hearing. I'll indicate, as I did last time, that this is an open court proceeding. However, the only request to record the proceedings has been made by the entity which is here. And sir, do you want to state your name and who you represent?
James Ptacek, independent on a documentary.
All right. So they were given permission through the proper procedure under Supreme Court rule to record these proceedings. No one else may record them. If anyone else is recording them, your device will be taken from you, and we'll rely on the official court reporter for the record here, and also the video recording that's being made for whatever purpose. All right. So last time we were here, the last thing we did was I asked the state to prepare a letter memo to the court to Mr. Barker about these various tapes that Mr. Barker is making claims about having been made in the discovery issue. So I'd like to deal with that first. Mr. Barker, did you receive a copy of the letter April 21st from the District Attorney's Office in Walworth County from Mr. Wiedenhoff?
No, I did not.
I did bring extra copies, Your Honor. I know that my office was attempting to electronically file this earlier in the week, but I think there were some difficulties because of the special prosecutor status and not being a Racine County office. So it may not have gotten actually filed and accepted until today.
Okay, I see the computer, right, where I got it from.
I did bring an extra copy.
All right, you want to give him a copy?
Oh, yeah, I got that.
You got that, okay.
I thought it was something else.
No, that's what we're talking about. You didn't get the letter on the letterhead of the Walworth County DA's office dated the 21st of April?
Yeah, I got it this afternoon.
Okay, all right. You had a chance to read it?
Oh, yes.
Okay, so what I'd like to do is go through the 4 paragraphs that are numbered there regarding the existence or non-existence of what is claimed to be a recording. I don't know if you need to make any statement. I think the document speaks for itself.
No, I would like to read my motion.
Just a minute.
Okay. The only additional information I can provide is in number 2 of my memo.
Yes.
I indicated that I was not able to find a reference to that the August 21st interview and reports. I did speak with the investigator today and did receive a copy of that report, which I believe Mr. Barker already has. So I do now have a report advising of a few initial statements that Mr. Golden made before indicating he didn't wish to speak anymore.
Objection. I have a copy of the report, and it's a full 2-page report of Investigator Brian Vanscyoc giving detailed information of what happened at the interview. And right here, this is the report right here I'm holding up. As you can see, it's 2 pages. It's dated, Brian D. Vanscyoc reviewed by Daniel J. Adams, and dated August 21st, 2015. It's a 2-page report with 1, 2, 3, 4, 5, 6 paragraphs of specific detailed information. So there's no way that he's saying that this interview didn't happen because...
No, that's not the issue. The issue is whether there was an interview. The issue, as I see it, is whether it was recorded or not.
Well, right here, I would like to read the last paragraph. It says, at this time, the interview was concluded with Golden as he had no further information to provide. I provided Golden with my business card with further information to provide. Oops, I'm sorry, I only got my glasses on. It says, I provided Golden with my business card with instructions to call if he had any additional information. The interview was recorded audio and visually, nothing further at this time. So he confirmed that the interview was recorded. He filed this report. He stated in it was audio and video recorded, and it's not like if it was like a 1-page memo or something, but it's a full 2-page report that was filed. And all of a sudden, inside of this, I would like to read the full report. so you can understand
The
why.
report speaks for itself. If I need to see it, I'll get a hard copy of it and I'll read it, okay? But I don't need to have to read it to me, okay?
But I would like to state for the record, I would like to read the report for the fact that spoliation of evidence, because this report right here is very important to my case.
Okay, let me just stop you there, okay? With respect to his reading a statement that indicates there was a recording made of the interview, Mr. Wiedenfield?
I agree that the report indicates that the interview was audio and visually recorded. My understanding is that the interview did take place in a room with audio and visual recording equipment. However, the interview was not saved onto a disc or preserved in any way. It just took place in a room with that recording equipment.
All right. Just a minute. So then the question is, was it recorded in any way?
Yeah.
Maybe we should take some testimony on that issue and on these other issues, all right?
Yes.
So we start there and build a fact record about these various recordings and what the reports say and what happened to them afterward and so on. We'll start from the very beginning, okay?
Objection, I'm trying to figure out what you mean by take some testimony.
We're going to have him put the witness on the witness stand and present testimony about these 3 or 4 statements that are involved here, okay?
Objection, this interview is, with this interview, this is called spoliation of evidence. He deliberately,
So we'll get to that, but first we're going to build a fact record about what the facts are with respect to these various incidents. After we have the fact record about what happened here, whether there was recording or wasn't recording, whether they exist or don't exist, whether they can give them to you or not give them to you, then we'll talk about spoliation. That's the issue that follows the facts. First we'll build a fact record, and then we'll talk about what the law is that applies to those facts. Okay?
I got the law. Would I
You'll be able to talk about the law when we get to that point, but not right now. First, we're going to take testimony, and the DA is going to present testimony. You'll be able to cross-examine witnesses and ask them questions about these various things, show them the reports if you want to, and so on. But first, we're going to present testimony, okay?
Objection. I would like to further elaborate on that. Spoliation of evidence, destroying evidence during trial.
First of all, we have to decide whether or not the evidence was destroyed or lost. That's what we have to do first, and that requires facts to be presented and facts to be found, okay? And we can argue that when we get to that point, so we'll go on from here, don't object anymore, all right? You want to have witness come up to the witness stand?
The state calls Investigator Vanscyoc.
Please raise your right hand. You swear the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Do I have the opportunity to call the witnesses?
You will. You'll have a chance to cross-examine this witness, and when the state's done presenting its evidence, you'll be able to present whatever evidence you want to present on this issue. But it's a narrow issue about these tapes and whether they exist or don't exist, okay?
No, I got further questions about this proceeding because I subpoena, I would like to have the Josh Golden and also Attorney General Sabina to be able to take the stand too.
You can call them if you want to. We'll see if they're available for you. Let's go on here, please.
I'm trying to catch up with what's going on because I've been trying to have one of these hearings where the witnesses take the stand, and all of a sudden he's taking a stand. But if I would have known, if I was made aware that witnesses was going to be able to testify today, I would have had Josh Golden and I was subpoenaing Josh Golden and Jennifer Sabina, so I object to him testifying today. I think it will only be appropriate if we have Josh Golden and also Jennifer Sabina come testify as well.
Okay, well, we'll see where this goes, and if you want to ask for those people to testify, we'll talk about that once we get this testimony on the record, okay? Let's go forward with the testimony. Please stop interrupting.
Could you please state your name?
Brian Vanscyoc.
Spell your last name for the court record, please.
Vanscyoc.
How are you currently employed?
I'm a sergeant at the Racine County Sheriff's Office.
How long have you been in law enforcement?
17 and a half years.
Did you assist with the investigation involving James Barker and some theft of lighting materials from a business?
I did.
As part of your investigation, was there an interview that occurred of Yvonne McNeil on April 23rd of 2015.
Yes.
Could you briefly describe for the court the circumstances surrounding that interview?
She was developed as having a relationship with a potential suspect. We met with her, I believe, at her residence and interviewed her inside her residence, Captain Adams and I.
A summary of her statements to you was provided, reported in a report, is that correct?
I don't have that report with me.
I have,
Do you recall preparing the report?
Yes.
At the time that that interview took place, could you explain whether the interview was recorded in any way?
It was recorded on an old department cell phone that was issued.
You said that was an old department
Yes.
cell phone? And could you explain how you attempted to record it on there, whether it was through an application or?
An application built into the phone.
Were you ever able to verify that the interview of Yvonne McNeil actually was recorded on that device?
I was not. I believe I attempted to when I tried to retrieve from the phone the interview. I was not able, either because the phone is now gone or because the recording was not there.
Was there ever a audio recording of that interview that you were able to download or have preserved in any way?
I have made numerous requests to our evidence custodian to attempt to locate that interview, so I do not believe that it was ever transferred to a DVD, if it was recorded.
Yvonne McNeil, as far as you know, isn't deceased or would still be available to testify if there was a trial?
I would have no knowledge, but I don't believe so.
objection, yes, she's available to testify for the record.
Stipulate to that.
All right.
I'd like to then move to the interview of Joshua Golden. Am I correct that there were two different interviews of Joshua Golden?
I believe that is correct, yes.
And one interview occurred on April 23rd of 2015, and that interview was recorded, and a copy of that has already been provided. Is that correct?
I'm sorry, what was the date?
And this would be the first interview that occurred
April 23rd?
on April 23rd.
Yes, I believe that's correct.
Okay. Then I'd like to move on to the second interview occurring on August 21st of 2015. Were you involved in that interview?
I wasn't.
Could you please describe the circumstances surrounding that interview?
I was contacted by the district attorney's office advising that Josh Golden wanted to make an additional statement in reference to information he had regarding the Vanscyoc Creek, and that was coordinated through his attorney, Jennifer Servino.
After receiving that information, were arrangements made to conduct an interview?
Yes,
Where was that interview take place?
at the Law Enforcement Center in the Detective Bureau.
Is the location of the interview, should that occur in a room which has the capabilities of audio and video recording?
It doesn't, not currently at this time, but at the time of the interview it did.
The discussion or interview that took place, was that later put into a report prepared by you?
Yes.
After the, did the interview that took place, was that the full interview that was anticipated?
I don't believe that. When I was contacted by Jennifer Servino regarding the interview, that Josh Golden provided me all the information that he had, which is why the interview was eventually concluded by myself.
After the interview was concluded, did you ever verify whether the interview was audio and visual recorded?
I did not.
Was the
Objection. You wrote in your report, that the video was audio only.
You'll have the chance to ask him that, okay? That's called cross-examination, all right?
Could you explain why your report indicates that the interview was audio and visually recorded?
That room, once you go in there, you turn it on to initiate the recording. I do remember doing that.
Do you have experience with the recording equipment in that room?
Yes.
Could you explain how it works then, where it goes from you flicking the switch to eventually a recording being preserved on a disc?
It's everything that's, once you initiate the recording, it saves onto a DVR, and then you can pull that information onto a disc at a later date or shortly after the interview is concluded.
Have you made efforts to verify whether or not the DVR, whether there was a recording of that interview on the DVR?
And that presents the issue in that DVR is no longer, as I stated earlier, that room is no longer recorded. And that DVR, as far as I can tell, is either been disposed of or its whereabouts are unknown. I have contacted our Lieutenant of Administration and asked him to see if he could retrieve that.
Were they able to retrieve it?
I have not heard one way or the other.
So the DVR that potentially could have recorded this interview, I guess would be whereabouts unknown at this time?
Yes.
Did you ever verify whether or not the recording of this interview actually was on that DVR?
I did not.
Are you aware if anybody verified whether or not the recording of that interview exists on that DVR?
I'm not aware. I did speak with our evidence custodian. He could not locate a DVD of that interview.
And to the best of your knowledge, Mr. Golden would also be available as a witness if there were a trial?
I believe so, yes.
I know that you were not the one who conducted any interviews of Mr. Barker, but are you familiar with the interviews of Mr. Barker?
Somewhat.
Are you aware of a time on April 23rd of 2015, initially where there was an effort to interview Mr. Barker, and he indicated that he didn't want to speak with Investigator Vandervest without an attorney present?
That's correct.
And that statement or the summary of that interview would have been recorded in a report
Yes.
of Investigator Vandervest?
Yes.
And Investigator Vandervest would be available to testify if there were a trial?
Yes.
I'd then like to ask you about the surveillance system that was collected from Mr. Barker's residence. Are you familiar with that evidence that was collected?
Yes.
Have you been able to verify whether or not the contents of that system have been downloaded by the sheriff's office?
It was.
And no further questions regarding those issues.
Mr. Barker, do you have questions you want to ask?
Sure.
Make sure you ask questions, don't argue with the witness, and don't testify yourself, okay?
Okay. Well, were you the officer who entered, were you part of the raid at my residence on April 23rd, 2015?
Yes. I would say search warrant.
Yeah. Did you flash a search warrant signed by you, omitting a judge's signature?
I don't remember who had a physical copy of the search warrant.
Well, I have a copy of the search warrant that you left at my residence on April 23rd. It omits a judge's signature, but it's signed by you on the face of the warrant. Do you remember signing the search warrant to my residence, 1412 West 6th Street?
There is a filed copy for your residence with a judge's signature on it on file in the clerk of court's office, yes.
I said, did you enter the home with a copy that was unsigned?
I don't remember.
Well,
There was several officers inside the residence with me.
Well, I would like to present a video of the search warrant he entered my home with. I got the actual video footage of them executing the unsigned search warrant signed by Investigator Brian Vanscyoc on the face of the warrant and amidst the judge's signature. It's a violation of Fourth Amendment right. Fourth Amendment requires that a search warrant be signed by a judge or a magistrate, not by an officer, and he took it upon himself to sign the search warrant instead of getting a judge's signature. So for that reason, all evidence should be suppressed.
We're getting ahead of yourself here. First of all, we have to have the evidence introduced. Do you have a DVD, something that you want to have played?
Yes.
It can't be played on your computer. It's got to be played in a way so it's visible to all people in the courtroom, and you haven't made any arrangements for that to be done. So the best thing we can do at this point is you can give us the video or the DVD. We'll mark it as an exhibit and put it in the record, and then I'll have to view it privately when I've got an opportunity to get to a machine where I can look at it, okay?
Well, I filed it with the courts several times, and for some reason it was never filed, but I do got a copy of a receipt from the clerk of courts that proved that I filed it on March 24th.
So I don't have the hard copy of the file here because the hard copies don't exist anymore. They're
I filed it.
digital, and it'll be in a separate place in the clerk's office where they keep exhibits. We didn't bring those here today because we didn't ask for them to be here. So we'll have to do it that way. I'll have the clerk's office look to see if there is the DVD in the court file that you filed before, and I'll do that one. If I don't have it to do, I'll have to let you know, okay?
Okay. I filed a hard copy and also an electronic copy of the warrant being executed by officers other than him. His name is just signed on the face of the warrant.
I understand.
But I did. I filed a hard copy and an electronic copy, but it has never been addressed. So this is a copy.
Hang on to that, and I'll make sure if there's one in the court file, we don't need another one.
Okay. Well, I would like to get this to the DA again. I'm handing this over to the DA
All right.
record.
Okay.
This is them executing the unsigned search warrant at my residence on April 23rd, 2015. This is a violation of my Fourth Amendment right. All search warrants should be signed by a judge or magistrate. I'm also handing the DA a copy of these unsigned search warrants that was presented to me. These are all unsigned search warrants, affidavits, and returns. They had a wrong issue date, and they also they're not signed by a judge, wrong issue date, plenty typo errors, and these were given to me while I was sitting in Racine County Jail. So that's again right there is a violation of my Fourth Amendment right. So you should take that. And then furthermore, as for the August 21st, so you have a 6-page, police report right here. It's dated April 24th. Reviewed by Daniel J. Adams, in 6 pages. Do you recall this report right here?
I would
Can't
have
see
to
it from
see
where
it.
you are, you have to have it marked and bring it up to him, they have him look at it, okay?
She said, do what?
The court reporter, I'm sorry, the clerk will have to mark it as an exhibit.
Okay.
Staple it all together as one document so that the pages aren't loose. Put staple on it for me.
It's able.
I also have, this is the unsigned search warrant that was left at my residence right here, signed by Vanscyoc, right there. That's the unsigned search
You
warrant.
want him to look at that, is that it?
Yeah, or you can mark it as exhibit too.
That's fine, we'll mark it as an exhibit.
Do you recall?
Did you have a chance to look at those, officer?
Yes, sir.
Okay, do you have questions now, Mr. Barker?
Yes, do you recall signing that search warrant?
I don't see that my signature is anywhere on this.
Your name is wrote on the top, it says
That
Vanscyoc.
is true, my name is written on it.
Okay, so you didn't write your name on it? Did you?
That
write-
is definitely my handwriting.
Okay, so, you used that warrant, did you use that warrant to execute?
I believe this is a copy of the face of a warrant. I don't know where you got this, so
Well, it's on video, where exactly, where?
I don't know if this is the piece of paper that this was provided to you. I don't know where you got this. What I'm telling you is for 1412 West 6th Street, there is a signed copy by a judge in the clerk's office upstairs.
Well, I will also present, a video of the clerk of courts stating that the search warrant don't exist. I filed that with the clerk's, in records on March 24th, 2017, the actual video footage of Racine County Clerk's Office, Racine County Felony Police Office, and also Racine County DA Office telling me and my attorney, Tony Young, we was there doing for inspection of records, and they told us that the search warrants don't exist. So if they're there now, I don't know how they're there. But so you were saying that you did not, you entered the door with a search warrant signed by a judge. That's what you're saying?
What I'm saying is that I cannot verify whether this is the piece of paper I got this or where you got this from. What I'm stating is that there is a signed search warrant by a judge for 1412 West 6th Street that was executed on that date.
I'm asking, but you're not answering my question. I'm asking you, okay, maybe there is a signed search warrant now, but I'm asking you, did you enter the door of 1412 West 6th Street using that warrant?
I have no idea.
You don't?
I don't.
I will leave that police report back that I gave.
Well, we kept as part of the record, their evidence you're moving and including here, we can make copies for you, but they stay here once they have an exhibit marker on, they're part of the court record, okay?
I need to read from it though.
Okay, you can come up and look at it.
You should sit-
Come on up and get
Not
it.
that I'm talking about the 6 page, not the warrant, but
He has the 6-page report right there, he'll get it for you.
Okay, page 1 states, it says it's a 6-page report. Okay, it starts off on April 2nd, and then you debrief what happened on April 2nd, and then you go off into April 22nd, 2015, and then you debrief the raid at my residence, 1412 West 6th Street, everything that happened. Then you end up at Yvonne Leo's residence, where you stated that you precise, you said, in paragraph 1 of page 5, you wrote, I'm starting with, it says, at approximately 1500 hours. So are you, do you recall executing a search warrant at Yvonne McNeil's house at 1500 hours on April 23rd, 2015?
If memory serves me correctly, I do not believe that that was a search warrant. We just made contact with her.
So it,
Can you read it again?
Okay.
I couldn't understand.
it said at approximately.
Right, can you keep your head up a little bit? Your voice is projecting down into the paper, and I'm sure the court reporter's having trouble hearing you. Try to keep your head up if you can, okay?
It is hard because I don't got my
Yeah,
glasses
let's
on.
hold the paper up a little bit, that'll help. Okay?
At April,
She needs to see your mouth, that's what
Okay.
I'm trying to understand what you're saying.
at approximately 14:15 hours, Lieutenant Adams and I responded to 815 H Street. Racine Police Department had conducted a stop on a vehicle leaving the residence at 1143 Village Street, in which we were preparing to serve a search warrant on. It says, the operator of the vehicle was identified as Yvonne McNeil, and the front passenger was identified as George Malone. Investigator Lewis and Investigator Chrisman stood by with Malone, and as Lieutenant Adams and I entered McNeil's residence with her permission. I conducted a custodial interview with McNeil, and the conversation was audio recorded.
Yes.
So you wrote in this report that you audio recorded Yvonne McNeil, correct?
Yes, that's been addressed.
So after you recorded Yvonne McNeil, what did you do with the recording?
As I stated earlier, that was on an old department cell phone. I have no idea where the whereabouts of that cell phone is. I obviously did not transfer that to a DVD or CD.
Do you know that Wisconsin law requires to preserve all audio video evidence?
Yes.
So why wouldn't you why wouldn't you preserve the evidence?
It was saved on a cell phone. What happened to that cell phone, I have no idea.
The report is the report is dated April 24th, 2015. In this same 6-page report, you also after April 23rd, you go off into April 29th. So my question to you is, okay, once you file, what is the significance on the date of the front of the report? It says 4/24/2015. It says report date 4/24/2015. So is that the date that you filed the report?
So you'll see at the top right-hand corner, there's an incident date.
Okay.
That's the date that our dispatch, the communications center, began a complaint number.
Okay.
The report date is a date that I initially started I opened that report that was assigned to me by dispatch. So if you see a date on there that says 4/20, there could have been things that happened prior to 4/20 or well after 4/20. That report date is really insignificant, other than that's the date that the report was assigned and probably opened by myself.
So you're saying that during your course of investigation, you kept going into this same report and editing it? That's what you're saying?
That's very common, yes.
So
Especially with large cases where a lot of things happen.
So you took all the information in this. So basically, so for you to go back into the same report, because you also have, there's another additional report that's exactly the same as this one. It's dated the same 4/24/15, and it's 5 pages, and all the information is the same, except in the middle of the report on page 4, you don't debrief on what happened at Yvonne McNeil's house. So the question is, my question is, do you think that you believe that is not prejudice towards the defendant who you're reporting on, if you're going back. So if I write something, you write something down today, and you say, this is what happened. I'm filing this report as truth, right? So you're going back into the same report several weeks later, and then you start adjusting, making it into, you're fabricating the report. If you write it on the face of the report that it was reported, the report date is April 24th, but you're reporting stuff that happened after April 24th, which is basically you're fabricating the report because.
Okay, now you're arguing with him, asking questions about whether he did that or didn't do it, but to argue that he's fabricating is not a correct statement of evidence. It's your argument, okay?
So, let's see. So you are confirming that on 4/24/15, you personally interviewed Yvonne McNeil.
If that's what my report indicates, that's what happened.
Okay. As for,
Let me just stop you there. So let me see if I understand this. Apparently the report date is the 24th, and there's information that's entered in the report that actually occurred after that date, is that right?
Sure, yes.
Explain how that happens, please.
So over the course of an investigation, when, like I said, when dispatch assigns you a complaint, that would be your incident date. That's on the top right-hand corner.
right?
The report date is the dates that I opened up the report that dispatch had assigned to me. Now, there are things that probably could have occurred, such as interviews or information that was garnished prior to the report date being opened by myself. And during the course of the investigation, there are obviously things that happen after the report date indicated on the report. And everything that happens should be indicated by dates, approximate times, roughly in the report. So to say that I could have went in and changed stuff, absolutely. I mean, things change, like I learn information. So there could be changes, but it's my report, my words, so.
Why not just file another report? Wouldn't that be proper procedure? Like, okay, you document what happens on 4/23/15, then you document on in the separate report, 4/24. Like, in my discovery, it's about 440-something different police reports. And just thinking off top, Investigator Petty, he has at least 10 different debriefings on 10 different dates of reports, and they each is separate reports. Why use the same report to go back in and adjust instead of just filing a whole new report?
Well, being heavily involved in the case as I was, there was a lot of responsibility on my head, including organizing and coordinating the swap warrant at your residence, report writing, interviews. So a lot of things that maybe Investigator Trippetti wasn't assigned to do. He maybe had some very specific tasks, whereas I had a coordinating effort throughout the entire case. There was lots of things that I had to do that maybe I didn't initiate a separate report for everyone, but that I just included in the entirety of the report. Does that make sense?
No, it don't. But,
Okay.
So, so what date did you actually file the report?
I'm not sure. Whatever date it was approved, I can get that information if you'd like.
Well, according to the report, it says.
Well, there will be a submitted date, an approved date, all that stuff is recorded.
Yeah, it says right here it was approved on April 24th, 2015. So you're saying that, so when you write these reports, they got to be approved, correct? Am I correct?
Reproved or
Oh, approved.
approved? Yes.
Okay, so how can Daniel J. approve this if you approved it on April 24th, that means he only approved everything, so he didn't approve nothing that happened after April 24th. He only approved what you documented on April 23rd. Am I correct? Because you said it has to be approved. So you got stuff that happened after that date. So
After which date?
after April 24th, the day he approved the report. So
May I see the report, please, to indicate what you're speaking of?
you document.
Just a minute, let me look at the report.
Can you show me what you are referencing?
Okay,
please?
you documented that on April 29th, you got bank records. You documented that on May 7th, I believe, you did another search warrant, and then on May 14th. So the question is, how could Deputy Adam Daniels approve that if you hadn't even got the debriefing from May 14th and May 7th to April 29th? That means that he didn't even approve. He said he approved. It says it was approved on April 24th. On April 24th, 2015, so he couldn't have approved the complete report. Only thing he could have approved is what you debriefed on April 23rd.
I could get you a copy of every time my report was submitted, every time it was looked at by a supervisor and eventually approved. Now, there may have been an instance where I submitted the report and I said, hey, can you reject that? I have more information to put in there. I don't know if that's what happened in this case. I can find out. That's all recorded through our Phoenix program.
Well, I requested, I went to the Sheriff's Records Department, requested that on several different dates. And I also have proof of emails of talking to Deputy William Dale, another deputy. Every time I went down and get records, I was even sent to Walworth County to get records. On June 17th, I was sent to Walworth County. They said the records don't exist. I have been denied my rights to inspect the records, the original records. And so, with that said, so you don't know what day you actually filed the final report, because I'm a pro se defendant, but I had an attorney at the time. So my attorney, he wants all the police reports and discovery. So he gets the discovery. I'm binding over for trial. We need a police report. Your police report is missing. Obviously, correct?
What's that?
So what I'm saying is, your police report has to be filed in order to give the defendant a chance to be able to review it. So obviously, if you debrief stuff that happened on May 14th, that means that you couldn't have turned that report in until after May 14th. Am I correct?
I would say that it may have been, like I addressed before, it may have been submitted, and then once something happened on May 14th, and it was maybe not approved at the time, I asked Captain Adams I asked him to reject the report so that I could add additional information and then resubmit it for approval. I don't know if that's what happened in this case. And like I stated, it is all logged in through Phoenix. I can find out.
So how am I supposed to know that you're not just going to go back and print out something, just like as if I object to that report, because I don't even believe that it's authentic. As far as I believe that report, evidence on the report shows that it was edited after May 14th. So if I got the report and it's dated May 14th, that means that you obviously didn't hand it in to May 14th. And then I have this email right here, correspondence email between DA Patricia Hansen and my former attorney David Sedana, and I would like to read the email to you. It says, I would like to try to read the email. Would you like to read it?
Do you want that marked?
I can't see it. Yes, but I can't read right now. I lost my mind.
Do you want that marked? Do you want the officer to see it?
Yeah, I want to, yeah.
You have a chance to read it? Okay.
Can you read it out loud for me?
Hello, Ms. Hansen. Just following up on when we spoke last Friday about your contacting the Racine County evidence person to allow me to come in with my investigator to view and take photos of the THC and grinder. I'm trying to get in there before the end of the week, if at all possible. Thanks and have a nice day. DS, signed DS.
Well, as y'all can see that I have very bad eyes right now. That is not.
That's not the one you wanted?
That's not the one I wanted. I have another email.
I'm going to cross the exhibit number off. That will give us back to you, okay?
Yep. I can pull the email up on my phone if I make it.
You can use your phone. If you put something on the record on your phone, we have to take your phone as an exhibit.
Oh,
You got to
okay.
have hard copies here, okay?
I just wanted to read it.
Well,
Okay, well, anyway, it's a June 19th. I have a June 19th, I believe, 20. It's Attorney David Sedana asking Patricia Hansen for specifically your police report, Nouse, Deputy Nouse, and Deputy Keith Dovish reports because they was missing from discovery in June.
so what is your question?
Basically, I'm trying to make a point is, you're the lead, it's correct that you're the lead investigator on this case.
That is not correct.
So who is the lead investigator on the case?
Investigator Vandervest.
Okay, Investigator Wiedenfield. So, but you stated earlier that you had a lot to do with this case, and because of that, that's the reason why you had to write a 6-page report. And so you may not be the lead investigator, but you're significant in the investigation in this case. Would you agree to that?
I would state that I am aware of the things that I did during this investigation, yes.
So do you think that it will be proper procedure to file a report before, at least before the criminal complaint? Because the criminal complaint was allegedly filed on April 27th, and the criminal complaint is allegedly based on statements that you made. So,
What is your question? You're making statement after statement after statement without formulating a question. We need a question that you can answer. Please state a question.
well, the question is, when did you actually file the police report? I need to
I
know.
think he's already testified. He's filed it numerous times that he has the habit, as the practice of the department, to amend the report as new information comes in, and then it gets approved by a superior officer, and then it gets filed. So the report's going to be always a piece of paper that's in development, so to speak, until the case is concluded.
So my question is, why wasn't those reports submitted to Discovery?
You wanted to how does he know what you were given in discovery? How does he know that? How can he answer that question?
Okay, well, I would like to be able to, I'm going to further finish cross-examining about the August 21st, 2015 interview.
That's fine, go ahead.
In this report, you state on August 21st at 1100 hours, I met with Josh Golden and his attorney, Jennifer Sabino. Golden and Sabino was escorted into the Detective Bureau interview room, and Golden was provided with a bottle of water, while Sabino declined. While Sabino declined, Golden was advised that the interview was voluntary, and he advised that he understood. Okay, so what was the purpose of this interview right here, August 21st, 2015, with Josh Golden?
I believe Josh Golden was interviewed prior to this interview. I was contacted by the district attorney's office, like I said, with coordination with Jennifer Servino. I was advised that Golden had additional information that he wished to disclose regarding this case and the involvement of everybody involved, and I arranged an interview on the 21st of August, 2015.
Was Golden able to, inside your affidavit, you linked me and Golden through Facebook, am I correct?
I believe that you were friends with him on Facebook, that's correct.
And inside the affidavit, that was one of your probable cause to ask the judge to request a search warrant, am I correct?
If it's in the affidavit, an affidavit is used to establish probable cause for a search warrant, that's correct.
Do you think it's sufficient that someone being Facebook friends with someone is sufficient for probable cause for a search warrant?
You can't answer, that's a legal conclusion. The judge who signs the search warrant decides whether there's probable cause, okay?
Okay, did you review, me and Josh Golden on Facebook records?
I don't know if a Facebook warrant was written for your messages with Josh Bolden. I'm not sure. I can't remember.
Well, according to reports, it was a warrant for me and Josh Golden's Facebook records, and it wasn't a connection between me and Josh Golden.
Is that a question or a statement? You can't testify now, that was testimony.
So were you able, during your interviews or through any discovery, ever able to make any connection between Josh Golden and I, between the times during interviews? Were you ever able to make any connection?
Like I said, it was established that you were friends on Facebook, and Josh Bolden, if you reference the report that I submitted, does reference your name in my August 21st interview with him.
He states, I provided a lengthy list of names to Golden. Well, you stated, I provided a lengthy list of names to Golden, asking if the individuals were involved, at which point Golden advised no to everyone's name except Santorino Avila. Was my name part of the lengthy list of names that you provided to Golden?
I would assume it was.
And he told you that I was, did he tell you, he said no? Did he tell you he told you I was not involved?
If I brought his name up then, and he said you were not involved,
Yeah.
then that's what he said. If I showed him your Facebook photograph, I would assume that I did. It also states here that Golden also advised that he had heard that James Barker III, who Golden I
We can change the proper time to say, but no further questions.
Any questions? Mr. Vanderbilt? Sorry.
That's it. Well, I would like to, I do have one more question for him, since he brought it.
You'll have a chance to recross him after he's done. Let him go ahead, okay?
Sergeant, I'm showing you what's been marked as exhibit number 3. Do you recognize that document?
do.
What is this?
This is a warrant signed by a judge for 1412 West 6th Street.
And this was the warrant that the defendant was questioning about earlier.
Yes.
The top page of that packet of documents, is that the actual warrant?
Yes.
What date was that warrant signed?
April 22nd, 2015.
Is there the second page of that document is called the return of warrant. Is that a page where you document when the warrant was issued, when it was executed, and when it was returned?
Yes.
Could you please provide that information to the court?
The warrant was received or signed on April 22nd, 2015 at 1:10 p.m. It was executed on the 23rd of April at 5:15 a.m. and then returned by Investigator Vandervest on 4/24/15 at 10:30 a.m.
And also attached in that packet is the affidavit.
Yes.
Is the date that the affidavit was signed indicated on that document?
Yes.
What date was that signed?
April 22nd, 2015.
And that was signed by you?
Yes.
I'd ask that the court receive exhibit number 3.
Any objection?
Objection, yes. I have, I would like for the court to allow me ahead of time to know that I'm gonna I'm not prepared to cross-examine him. If I would have known that this was going to happen, I would have came prepared to cross-examine. I came today prepared to argue my motion to dismiss, and here we go having a cross-examination hearing. So it's like every time I come to court, that I'm thrown off balance because something other than what the procedure that we was coming for happens in between scheduling the court date. So
Last time we were here, you asked for time to be able to present witnesses on an evidentiary hearing on your motion to dismiss. So we continued it for your convenience to do that. In the meantime, the court also, as you were there and heard, asked the DA to prepare a list of memo to the court and to you about those four things, the 3 statements and the surveillance system, which he has done and given to you. So you had full notice of what we were going to do today. If you wanted witnesses, you could have subpoenaed them when you knew we were going to talk about these things.
yeah, but I think I filed with the courts indigent form so you can waive my fees, and I haven't heard anything back from the courts.
I have not seen an indigency form.
Well, I filed it. I can prove to you that I filed it several weeks ago, and I never got a response back.
Okay.
So when I don't get responses back from the court, I don't know what's going on. So I can't afford to subpoena nobody. So that was the reason why I filed that form, so you can waive my fees, so I can subpoena people to trial and to the hearing. But I never got a response back.
Okay, well, with respect to an evidentiary hearing, again, you've had notice in terms of what we're going to do today. In terms of whether you want to ask for time to subpoena witnesses, this could go on forever if we don't keep you moving forward. And you seem to have the ability to drag your feet to go in all different directions. And I understand that some limitations here because you're not a trained lawyer and representing yourself, and that's difficult for anyone. But you have difficulty focusing on the issue and going off in all these other directions, and we're trying to address something to get it done and accomplished, and it's not helping to move things forward here. So, do you have any other questions of this witness?
Well, I would like to address what you just said too. I'm indigent.
Okay, let's go on here. Do you have any other questions of this
Yes.
witness?
Who, as far as so that search warrant, the face of that search warrant is it issued dated April 22nd, 2015?
Yes.
Who is the notary on that search warrant?
The doctor's signature, I can't even read it.
So you don't know who notarized it?
I would assume it was one of the investigators in the Bureau.
What is the procedure when you typed out did you type out the affidavit?
Yep.
So you had to go and get it notarized, right, correct? Is it you that gets notarized? You got to swear to it in front of a notary, correct?
I have to provide that this is my affidavit, yes.
But I'm asking you, so you have to swear to it in front of a notary, am I correct?
Yeah.
So, but you don't know who the notary was that you swore to it in front of, huh?
You know, if I went back and found who signed this, I'm sure it was one of the investigators inside the Detective Bureau.
For subpoena purposes, I need to know who the notary is on that affidavit. So you can't give me no name of anyone to check the legitimacy. I would like to look up the notary. Do you know that it's Wisconsin statutes 137.04 that notary publics must apply the notary seal to a document?
Yes.
Is it a notary seal on that document?
So it looks like this is obviously a copy. So when a stamped seal gets photocopied, it obviously is not as clear as it would be, but I can see some type of embossment that was photocopied.
Well, Wisconsin statute states a clear impression of a notary seal.
So the
That's a
original,
legal argument you can make to the court, but not to the witness, all right?
So
It is what it is.
But you can't provide me with the name of the person who notarized it.
that's not what I stated. I said that I could probably ascertain as to who did sign it, but I can't do it right now because I can't read the signature.
Okay, can you read that alleged electronic signature on that affidavit?
weren't electronically approved by District Attorney Rich Chipetti.
So what does that mean? What does that mean by electronically?
It means that a copy of the search warrant was signed or sent via email to Rich Chipetti. He read it over and he approved it.
So is that like for instance, I believe on the face of that warrant, it got like electronic, when something's approved by the clerk of court, they put an electronic stamp on the front of it.
That's a hard stamp. They put it into a stamping machine.
No, that's electronically done. When,
Talking apples and oranges here, okay?
I'm trying to figure out the legitimacy of the. So you're saying that's is that a typed in? Did Chipetti type in electronically approved?
No, that
Or
would have been typed in by myself.
So you typed in that electronically
Yes.
approved? Okay. I went to the Racine County Felony Clerk's office on April 14th with my attorney, Tony Young. We requested a copy of the original search warrant with the seal. They said the search warrant don't exist. Did you see that video?
No, I did not.
I will be providing the courts with a copy of the video of Racine County Clerk's Felony Clerk.
Okay, well, the video speaks for itself. If we have it here, this witness has no knowledge of it, so he has no ability to answer any questions about it. So let's go on to something else here, okay?
Well, I would like to read my motion. I filed a motion, and I would like to state the
You
record.
filed many motions. Which motion is it?
The motion that I recently filed that we're supposed to address today.
Which is entitled what? Before today, at least on today's date, you filed at least three things that I have here. Demand for discovery, witness list, motion for sanctions, motion for dismissal.
Yeah, motion for-
You have an earlier motion that you filed that's longer, that's a motion for dismissal with prejudice.
We can focus on the motion for the motion for sanctions.
Okay, are you done asking questions of this witness?
Yes, I'm done asking questions.
Any further questions by the stage?
No.
Okay, thank you. You may sit down. So now you want to be heard on a motion?
Yes.
And the one you want to be heard on is,
Defendant's motion to dismiss sanctions.
okay,
Okay. This motion, I present to the United States Constitution 4, 5th, 6th, 8th, 13th.
you don't have to read it. We can read it, okay?
But I think it would be better if I state the record by reading it.
You don't have to read it into the record. It speaks for itself. It's marked as an exhibit. It's in the record. I can read it, okay?
Well, when I have previous attorneys, every time it was motion, they read the whole motion off the paper, so I don't see why I can't do the same thing.
You don't need it read into the record. It speaks for itself. We have it marked. It's part of the record. It's been filed. It's here. It's in printed form in the court file, okay? You can argue and want to make a statement. I'm not going to allow you to read this from cover to cover. You don't need it read. It's in the record. It's a printed document, okay? I've read it. You want to say something in addition to what you've written there?
Yes, spoliation of evidence. The courts have admitted that they don't have, they admitted that they don't have the discovery, the interview August 21st, 2015 with Josh Golden, the April 23rd, 2015 interview with me, my surveillance equipment, and the April 23rd, 2015 interview with Yvonne McNeil. All of this is significant to my case, and Supreme Court has ruled that, let's see here, that's why I wanted to read my motion. Spoliation of evidence.
Okay. First of all, you're sort of ahead of yourself here. The first thing is, what are the facts that exist with respect to these various statements?
The facts is,
Whether they existed at some point in time, and whether they had an obligation to retain them and keep them, what they contained, whether they were helpful to you in your defense or not, whether they were inculpatory to you in your defense. It seems to me that you wouldn't be upset if they lost a statement from somebody who made statements against your interests.
they did make statements, they made exculpatory evidence that liberated me from the case, and that's the reason why they're considering the interview with Josh Golden. See, I interpret the interview as they need to establish a conspiracy connection. I'm being charged with conspiracy with two people that said they're not have no connection to me at all. So when he went and said an interview with Josh Golden on August 21st, actually, if you read the whole interview, it seems his goal was to establish a conspiracy connection between me and Josh Golden. But Josh Golden, as he stated he couldn't give any information about me. Therefore, when Josh Golden stated that, they're concealing the interview, and I don't know, maybe they're concealing it because it probably wasn't Brian Vanscyoc who actually took the interview. Maybe the whole document by him was another officer. Maybe, I don't know what it is, but I have a right to discovery. That's my amendment, 14th Amendment right to discovery. And they are bound to preserve evidence for trial, and they have destroyed evidence before I even went to trial. And because of that, my case should just be dismissed on that. They obviously destroyed the evidence in bad faith or in reckless regards. However, but he had the full-page reports documenting this interview, and he stated that the interview was audio and video recorded. He also stated there's also other police reports stating that other additional people was interviewed, and it seems that everything that can help me with my case, all of a sudden it just disappeared. They can't find it. In the beginning, it was 441 pieces of discovery in my case, and not one piece of those 441 pieces of discovery implicated me in being involved in this case at all. And here it is, 3 years, I'm still fighting the same case, even with the TAC case. The TAC was inventory 3 days after my arrest.
Mr. Wiedenfield, do you want to be heard on whether there's been spoliation here?
Yes, please.
Go ahead.
Regarding the 3 interview recordings that I believe the defendants alleging were improperly destroyed. First, I don't believe that there's sufficient evidence at this time to conclude that those recordings ever existed. There's been testimony that there were efforts to make some of these recordings, but we don't actually have confirmation or evidence that the recordings existed, that they were in a means available for law enforcement to copy and provide to the defendant, or that they somehow were able to preserve them. But certainly there were efforts made to record at least 2 of those statements. The one that there is no indication was recorded was the defendant's invocation of his right to an attorney, which has no evidentiary value at all, exculpatory or inculpatory, and really wouldn't be admissible at trial just to show that he invoked his rights. The cases governing preservation of evidence, the main case is California versus Trombetta, Trombetta, the U.S. Supreme Court case, where they say that before the state can be said to have violated any duty to preserve evidence, it must be shown that the evidence possessed an exculpatory value that was apparent before the evidence was destroyed. Here, I don't believe the defendants made a showing that this evidence was exculpatory in any way, or that the evidence was destroyed. I don't think he's shown that it existed to begin with. Second, that case requires that the evidence must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable available means. Here, he certainly could call the law enforcement officers involved. He could call those people who were interviewed and obtain statements from them in that manner. The other case...
Objection to that.
Just let him finish. You'll have a chance to respond, okay? Don't interrupt.
The other case, which involves evidence that may potentially be exculpatory, which I think at best is what the defendant can argue, is that potentially this evidence was exculpatory. That's governed by the U.S. Supreme Court case, Arizona versus Youngblood, which requires that in order to say that there is a due process violation, the defendant would have to show that there was bad faith on behalf of law enforcement that they made efforts intentionally to destroy this evidence. Based on the testimony of law enforcement today, clearly that if there was evidence that existed and it was destroyed, it wasn't done in bad faith in some sort of effort to hide or conceal this information. I think just by this information being shown in the reports demonstrates that there was no intent to hide or conceal or destroy this evidence. So for those reasons, I'd ask that the court deny the defendant's motion for sanctions or dismissal.
Respond?
Yes. That's all. So, what you said, it says, that's why I want to read the whole report, the whole story. I'm gonna have to read some of this to get to where I'm going. Apparently, they attempted to establish a connection for a third time in the August 21st, 2015 interview, but instead of getting Josh Golden to make incriminating statements against the defendant, James A. Barker III, Golden made statements that exonerated Barker from his conspiracy to theft charge. Therefore, the state is attempting to conceal or has destroyed the interview in bad faith rather than drop Barker's pending conspiracy to theft charge, which constitutes violation of spoliation. American Family versus Goethe Brothers. It says Wisconsin trial courts have discretion in imposing sanctions for spoliation of evidence. However, a party's duty to preserve evidence is discharged once the party in possession has reasonable notice of possession of a possible claim. The basis for the claim, the existence of evidence relevant to the claim, and a reasonable opportunity for inspection of the evidence. In my case, the state is claiming the video evidence don't exist, therefore reasonable opportunity for inspection of the evidence hasn't been provided to the defendant. So I'm sitting here with the police report in front of me, and he said on the police report that it was audio and video recorded, and they're telling me it don't exist. Furthermore, it says in Hopkins versus Dodge County, sanctions cannot be considered unless there is clear and convincing proof that evidence was deliberately destroyed or withheld. When deciding whether and how to sanction a party who has destroyed evidence, Wisconsin courts consider the circumstances, including whether the destruction was intentional or negligent, whether comparable evidence is available, and whether at the time of destruction the responsible party knew or should have known that a lawsuit was possible. Farr versus Wiedenfield, Garfield versus Fireman Fund. It says the court held that dismissal as a sanction for destruction of evidence requires the finding of egregious conduct, which in this contest consists of conscious attempt to affect the outcome of litigation or flagrant knowing disregard of the judicial process. In this case, the state destroyed evidence during litigation of the defendant's criminal case after the evidence had already been ordered returned by 2 judges, resulting in disregard of the judicial process, gross negligence, egregious conduct, and several violations of the defendant's substantial due process rights. Now, for them to destroy evidence when I have been booked, sitting in jail, I'm charged, and so everything from April 27, 2015, of the day of my initial arrest, all the way until now, they should know to preserve all of this evidence. Don't destroy anything. How am I to know if anything else was said inside those interviews that was also exculpatory evidence that liberated me? They already don't care. I'm charged with a conspiracy case with 2 people that has admitted that I have no involvement. And so, yet alone, the August 21st, 2015 interview was done on August 21st, 2015, during my first attorney, And I never even got I didn't receive a copy of that interview until November 8th of 2016 from an attorney that I never even had. I just started getting emails from an attorney stating that, and at the bottom it said Ritter, Attorney Ritter, and he was a public defender. I never met him before. And so somehow he did this August 21st, 2015 interview, and I've filed several motions to compel discovery, several discovery demands, and I even have a detailed list of discovery given to me by Mark Nielsen. And not once was that August 21st, 2015 interview mentioned or any of that. So that shows that they were trying to conceal that video recorded interview. And I do not know what was said on that interview. But one thing I know from reading from the police report, that his whole intentions was trying to get Josh Golden to incriminate me. It didn't happen. So because of that, because of the concealment of the August 21st, 2015 interview, the concealment of the April 20 of the surveillance equipment, the concealment of the Bobby Mills interview, and also the April 23rd interview of me at 7:45 was the coincidence on 4 pieces of discovery during litigation just coming up missing. That shows that that's gross negligence, or they're trying to affect the judicial process. And so because of that, that prejudice being the violation of my 6th, 8th, and 14th Amendment right. And for that, the case should just be dismissed.
Right. The issue is whether the court should grant Mr. Barker's motion to dismiss based upon statements that he alleges were recorded and not available. It's clear that the law, the standard at this level is clear and convincing evidence to prove that evidence was deliberately destroyed or withheld, and destruction can be intentional or negligent. We have to also look at other factors to determine what the evidence was that's alleged to have been missing, whether there's comparable evidence that's available, whether at the time of the evidence being destroyed or lost, the custodian knew or should have known it would be evidence necessary in a dispute, a case like this. There really are 3 things that are argued here. One is the statement of Ms. Yvonne McNeil on April 23rd of 2015. The testimony of the officer involved is that that statement was recorded on a department old cell phone, and that through an app on the phone they record it, and then it gets transferred to a DVD. And he indicates that he was never able to verify that it had been actually recorded. Either the phone was gone or the phone was not there. He made a request to produce the phone, believes it was never transferred to the DVD. And he notes, and the testimony reflects that this witness, Ms. McNeil, is still available. The question is, what is the evidence she would give? And according to the report that's written by the witness who was here and is part of the exhibit number 1, it indicates that officers went to Ms. McNeil's residence, entered with her permission. They interviewed her, and they recorded the interview. She was read her rights verbatim. She said she understood them and wanted to answer questions. And here's what she said. She advised that she'd been seeing Malone for several years and that he worked at Cree at the Grandview location. She advised that 1143 Villa Street belonged to her and that it was vacant and had been for several weeks as she was trying to sell it. She advised she had no knowledge of the Cree product thefts and allowed search of her residence with her consent, and nothing was found of value. And that's the end of what the content is. So Ms. McNeil is still available to testify, could be brought to court. And what she said here is not incriminatory to you, Mr. Barker. She said she knows you and that she owns the property and that she never saw any product. That's basically it. There's no incriminating statements there that in any way incriminate you with respect to what's alleged here in terms of the criminal conduct. So, as I see it, there's no exculpatory evidence. She's available, and we have to look at what it is that's lost here, if it was lost. I can't find that this was an intentional destruction of evidence. It's clear that the department was using an outmoded method to record a cell phone, and it's clear that apparently there was the belief on the part of the officer who testified that the phone, if it was available, they would use it to transfer this conversation to DVD, but I'm not satisfied I can find that this in any way deprives you of any evidence that you want to present at the course of trial. I guess the only thing I could see might be is if she were to come to testify to something completely different and incriminate you in some way. Then perhaps it might be evidence that would be helpful to you because you could impeach her by the former statement that she gave that says you didn't know anything, basically. But that's not the circumstance here. So I'm not satisfied that statement, which I believe was recorded, and if it was recorded, there was no intentional destruction of the evidence, and certainly the Sheriff's Department, I hope by now, has improved its system to update technology and so on and to find better ways to record statements. The next statement is the statement by Mr. Golden. And he was apparently contacted by law enforcement with his attorney, Ms. Severino, who I don't believe is in the area any longer. I think she left the area, if I'm not mistaken. She may have done that some time ago while I was still on the bench before I retired. I do recall back in my mind somewhere that she came around and said goodbye to everybody because she was leaving the area. That is just an aside. This interview takes place in the Sheriff's Department in a room that's equipped with recording and audio and visual recording devices. And then the report of this matter indicates that there really was nothing new that the officers obtained from this witness. Again, Mr. Golden, who is still further a person who's available to be brought to court to testify. The officer believes when he entered the room, turned on the equipment to initiate the recording. It then gets saved to a DVR, then gets put on disc, but that at this point the DVR is no longer in that room, and that room's no longer used for that purpose, that the equipment's been disposed of, that the whereabouts of this particular recording device, the DVR, is unknown. He did ask the lieutenant in charge of administration to find it and has not gotten an answer. I guess what I'd say is that needs to be followed up on to see if there still is a recording that might be available. I'm not satisfied we're at the dead end there on that one, but I'm satisfied to be able to state here, as in the earlier case, there's nothing here to indicate the destruction was intentional, that it was destroyed by the officers. In any way, it's not clear here that it was even recorded if they don't have the equipment to see that it's on there. There's a belief that it was recorded. The deputy pushed the button, all things working properly, then it was recorded. But again, they can't seem to be able to produce it because of the change in the physical setup, moving of equipment, and perhaps the destruction or loss of the equipment that was used for the recording. And again, Mr. Golden himself is still available to testify. And again, there's no incriminating evidence there either, really.
Objection. Can I state something to that?
No, it's my turn to talk now, okay? So I'm satisfied that with respect to the Golden statement, that's objected to because of the lost recording, if there ever was one, that there is no infringement on Mr. Barker's constitutional rights with respect to that recording not being available to him at this time. And again, we'll follow up to make sure with the lieutenant of administration that it doesn't exist. I mean, if it does, the court and the defense should be notified by memo to the court file as well, right? As it relates to the surveillance system in my mind, it's not clear to me what Judge Flancher did order, but it's a piece of physical evidence. It's evidence of a crime. It recorded something that happened that is criminally involved, then the equipment itself is evidence of a crime, just as the information that's recorded on the device is evidence of a crime. And I'm satisfied that there's no basis for that being found to be spoliation or for there any evidence there that's being concealed or lost. It's simply being held, and I understand that your dad basically wants it back again, right? He wants the equipment back, and that'll happen eventually. All cases end, in one way or another, and the equipment does eventually get returned, but I'm satisfied at this point in time. It is evidence of a crime, so.
My question to that is, demand discovery, don't I have a right to all digital?
Yes, and I believe they've made that available to you.
No, they did not. They have not made it available, and if you read Flancher's court order, which on January 29th, Judge Flancher's court order, she specifically say, return the surveillance on within 30 days of the filing date, which was January 30th, so that would have made it March 30th, roughly. She said return the surveillance, but this wasn't the first order. This wasn't the first order for the return of the surveillance. This was like the third order. It was also ordered to be returned back in June of 2015. And the judge kept having my dad come to court. He came to court from June all the way to September. And every time he came to court, Patricia Hansen kept making an excuse on why the crime lab had it. We'll return it after the crime lab. Then when he come back to court, the crime lab was on vacation. And here he is, 3 years later.
Okay, let me just ask the state what its position is with respect to not the data on the equipment, but the equipment itself, and where is it, and whether it should be returned or not.
In regards to Judge Flancher's order, that was specifically, the surveillance equipment was specifically addressed in that order, saying that the defendant could make arrangements to view that evidence at the sheriff's office. I don't know whether he chose to view it or not, but the order didn't indicate that it needed to be necessarily turned over, just that the defendant would have the opportunity to view it.
Objection.
However, I have spoken with Deputy Dale from the sheriff's office, and he's told me that they have downloaded the entire contents of that surveillance system. So I have no objection to that surveillance system being returned to the defendant's father, since he's the rightful owner.
Right, so they're agreeing to return it. Who has the receipt for the evidence? Do you have it, or does your dad?
The receipt?
Yes, they give you a piece of paper that's a receipt showing that they took certain items into custody, and when they did the search warrant. Do you know who had the receipt? Was the receipt issued to you or your father for that piece of equipment?
I don't know, I wasn't there.
Yeah.
I was there.
I'm sorry, ma'am, would you state your name, please?
Carmen White, I'm his mother,
Last name?
White.
Okay.
I was there, they didn't give us a receipt. They
There's
just
a
told me
receipt
that.
somewhere. If it's not in your hand, it's in the records of the sheriff's department. Who would have been taken from and who it should be returned to. So,
They were his father right there.
Can I further elaborate on that surveillance equipment?
One additional point, so the return surveillance equipment will have the contents, but since that's going to the father, if the defendant on his own wanted to obtain a copy of that downloaded contents, he could take he needs a device capable of storing 2 terabytes of data. It's a large amount of data, and they would then download it onto that device for him.
okay. Do you understand that, Mr. Barker?
Yep.
Okay. So, Mr. Barker Sr., I believe you're James A. Barker II, is that right, sir?
First.
First, okay. apparently the sheriff's department's agreeing and the state's agreeing that the equipment, the surveillance equipment, can be returned to you. Do you have a receipt or something that you were given at the time it was taken from your residence?
I don't remember getting a receipt. All I know he gave me the recording. I don't remember. It might have been 3 years ago.
Yeah. So what will he need to get that equipment from the sheriff's department? Mr. Wiedenfield.
I think a driver's license or some other photo identification, like he'll come up as the owner of that property and then would be able to pick it up. And I have communicated with Deputy Dale already, telling him that I have no objection to that
All right.
evidence being released.
So if he goes to the sheriff's department and asks to talk to Deputy Dale and then presents his driver's license, they will return to him the surveillance system. Is that correct?
Yes.
You hear that, Mr. Barker, in the back?
Yes.
Can you do that?
Sure can.
That would help us a lot here, get one more issue off the table, so to speak, all right? And as he already said, maybe you didn't hear this, but the data, the recording is still on the machine, all right? So it's still there, and if your son, is your son or your grandson? Son. If he wants the data off there, he has to get some equipment to do that, and apparently whatever it is on there, the recording, it's a huge amount of data because it's video. And I don't know how he does that, but that's up to you and him to figure out, okay?
I know how to do it.
You know how to do it? Okay, all right.
Now, as far as the video of them executing the unsigned search warrant,
Could you give us the name of the deputy again?
Deputy Dale,
Deputy Dale.
William Dale.
William Dale, okay?
Okay.
Gonna write it down somewhere?
Yes.
I got an email right here.
Okay.
Our correspondence emails where he told me I could view the evidence, I could,
All right.
well, yeah. So, as far as, the industry form I filed,
I'll look for it. I'll have the clerk search and file for it. My computer shut down on me and it won't let me back in again because I'm a reserve judge. It's kind of difficult to maneuver into the system. So I'll have them look for it. If it's there, I'll sign it. We'll have them contact you to let you know that it was signed, okay?
okay, because, I need to know the procedure on subpoena.
Yes.
Because, like, for instance, I filed it at least 2-3 weeks ago, and I was planning on subpoenaing people to court, but I couldn't because they never filed it. So I wasn't prepared, only just to argue my motion. But I got, there's been subpoenas sent out through mail for witnesses. How many subpoenas did you send? I only have a witness list.
I do have today a amended discovery response that I can provide to Mr. Barker. The address mailing address we have for him, it came back in the mail,
Okay.
so I don't know if he has an updated.
Where do you receive mail?
I am an electronic party, so everything he do can be electronically filed.
Well, that means it's going to the court file, right?
Huh?
Okay.
Excuse me, I ain't hear you.
That means it goes to the court.
Yeah.
That's how the court wants to proceed. I can electronically file all
right.
correspondence.
Okay.
But I do have a paper copy I can provide him today.
All right. You're doing that now?
Yes.
All right. So let me just see here, there's one more thing that you do today before we're done. Can we talk about the things you need to do to prepare for trial? There is a demand for discovery and inspection motion that the defense filed today. It's a number of pages and a lot of different paragraphs. Can we run through those briefly to see if there's any issue? All right. You have your document in front of you, Mr. Barker, so you can follow along?
Oh, my.
This is demand for discovery?
Yes.
So I'll just summarize the paragraphs and we'll see where we are with these, all right? So the defendant, his motion for discovery and inspection is demanding that he be given copies of all oral, written, and recorded statements made by him concerning this event, etc. Mr. Wiedenfield.
There were two interviews. The one was where he was just read Miranda and asked for an attorney, and the interview stopped. There is not a recording of that request to give a statement. The other interview of the defendant has been provided.
Okay. Secondly, furnish the defendant with a copy of his criminal record, etc. Any objection to that?
Yeah, I have objection to the first one he said, because according to law, that first interview, I would like to just read the law on when it comes to interrogations. It states recording custodial interrogations. It says custodial interrogation. This is Wisconsin Statutes 968.073. Custodial interrogations means an interrogation by a law officer or an agent of a law enforcement agency of a person suspected of committing a crime from the time the suspect is or should be informed of his or her rights to counsel and to remain silent until the question ends. So basically, I have the copy of the your rights form, waiver form, right here. Well, I think well, I have a copy of it, but I obviously don't have it with me. The rights waiver form with allegedly Investigator Brian Vanscyoc. I mean, not Vanscyoc, Vanderbilt, Donald Vanderbilt. And the time, here it is right here. This is the rights waiver form.
I don't need to see that.
Okay. Well, the significance of this is he's saying that he interviewed me on April 23rd, 2015 at 7:50 a.m. consistent with the police report. Now, but at the same time of him saying he interviewed me, in other pieces of discovery, he's claiming to be somewhere else. And so...
Okay, well, that's something you can question him about if he gets on the witness stand and cross-examine him. But discovery is giving you what exists, and they're saying they're going to give you a copy of your written and oral and recorded statements. They've already done that, right?
Yes.
The second issue is whether there's his copy of his criminal record. Have you provided that to him, or can you?
We aren't able to provide copies of the NCIC reports, but since the defendant is representing himself, he's familiar with his own criminal history. If he has any specific requests on...
Well, if you have a criminal record of his that you're going to use to ask to have the court determine how many prior convictions he has, that would be what you'd be giving to him. You have that?
I don't have that this time, but before trial, I'll have one prepared.
All right. Okay, so he's agreed to give that to you before trial. 3, copies of the reports of the defendant's conduct, which it intends to introduce, that may imply admission and the names of any witnesses to them. Do you have any conduct that you're going to introduce that would suggest admission on the part of the defendant?
Any conduct would be provided in the reports that have all been provided.
Been provided, okay. Next is to furnish him with a description of the evidence which you intend to introduce. Is he aware of all the evidence that you're going to introduce, physical evidence?
Yes, all the physical evidence and reports are documented and have been provided to him.
Okay. Next is the list of names and addresses of persons known to the state, who the state intends to call as witnesses, etc., and any oral or written statements they have. Given in the witness list today.
Yes, he got the witness list today, and their addresses are also on that list. Their addresses and probably more contact information are in the reports which have been provided.
All right. The next paragraph is number 6, copies of any record of prior criminal conviction or juvenile adjudication of witnesses of the state.
Prior to the trial, the state will research prior convictions of witnesses. We can make a record on those the morning of trial if the court approves.
Okay. Next is to furnish a list of names and addresses of persons known to the state or any investigative agency whom the state does not intend to call, who have given information relevant to such investigation and preparation of the case, etc.
That has all been provided.
All right. Next is to disclose to the defendant any promises and rewards regarding this case. I assume that's to witnesses. Is that right? Is that what you're asking for? Paragraph 8. On paragraph 8. Just follow along.
I can't, I mean, I'm looking at it, but I can't see it, so I mean, it's like, I'm just trying to...
I assume what you're looking for there is promises or rewards, things given to people in exchange for their testimony or cooperation. Is that it?
Yes.
Okay. Any of that?
I'm not aware of any, but if there were, it would be referenced in reports.
All right. Next is to furnish defendant with all reports and statements of experts. Are there any experts being called here?
I don't anticipate any expert testimony. There may be some records custodians.
All right. Next is to furnish the defendant for inspection all physical evidence you intend to introduce.
He's been given the opportunity to view evidence already.
Objection. I've been down, I went to inspect evidence several times, and I even have a video recorded of me going down there, and every time I got the email, everything, all my correspondence with the alleged evidence custodians, I talked to them through email, or so I got documentation of what happened. So I give the evidence custodian, I contact, first it was, I think her last name, her name.
So what's the issue? Have you seen the evidence?
No, I haven't.
Why not?
Because Deputy Dale, when I went down there to view the evidence, they had me fill out a form, and instead of allowing me to view the evidence, they gave me a folder and charged me $30 for it. It wouldn't allow me to review the evidence. And then when I made the second attempt, Deputy Dale, he sent me this email. He sent me an email basically telling me you can come and review the evidence, but
I'll ask you, Mr. Wiedenfield, if you would contact Deputy Dale to get a date and time for Mr. Barker to report to the evidence area of the Sheriff's Department so that he may view the physical evidence, all right?
I will.
All right. Next, furnish the defendant with photographic copies of any photographs shown to any witnesses, such as for identification purposes, I assume. Were there any show-ups or photo displays that you're aware of, Mr. Wiedenfield?
I'm not aware of any photo lineups.
Okay.
But any reference would be in the reports.
All right. Paragraph 12. Any books, papers, documents, photographs, tangible objects, physical evidence, which were obtained from the defendant's personal automobile or residence. Is that all the evidence in the evidence custodian's control will be available to him when he views the evidence?
Yes.
Okay.
Yeah.
Number 13, furnish the defendant with relevant information provided to the state by any informant. Were there any informants here that you're aware of?
I don't believe there are any confidential informants.
All right. 14, furnish the defendant names and addresses of any informers involved in this case.
I'm not sure if that's different than a confidential informant, but if it means disclosing witnesses, they're provided in the reports.
All right, all witnesses are named in the reports that you're aware of?
Yes.
Okay. 15, furnish the defendant with any and all exculpatory evidence. Do you understand your obligation under law to provide exculpatory evidence, Mr.
Yes.
Wiedenfield?
Yes, and we have done so.
Okay. And then under 15, there is
objection to that. I object to that. You haven't provided me with exculpatory evidence. I'm still missing the August 21st, 2015 audio court interview.
We've already talked about that, okay?
Yeah,
We always know those are not, they don't exist or they are.
Just for the record, I just want to
Okay.
object to that.
All right. Then he has a whole list of things that he's asking for under that category, exculpatory evidence, which I think is dealt with in the body of the statement itself. It's just generally exculpatory evidence. He's listing something specifically, but that's covered by the phrase exculpatory evidence, in my opinion. Okay? 16, to provide the defendant with a description of any of his property which has been seized, which has not been returned to the defendant. Is there any property that you're aware of that's been seized that's not listed in the reports?
No, it's all in the reports.
17, furnish the defendant with written or recorded statements and the substance of any oral statements made by the alleged victims. Any statements from the victims that you're aware of that are not in the reports?
There are statements from the victims in the reports. I'm sure that they have their own, their business, so they have their own internal records, which wouldn't be in my possession.
All right. Furnish the defendant for inspection, paragraph 10. Any physical evidence, which is what we intend to do while you're going to the evidence custodian, right?
Yes.
Okay. 11, furnish the defendant with photographic copies of any photographs. Again, that's repeating itself. Again, there were no photographic show-ups or lineups that were used to your knowledge, Mr. Wiedenfield?
Correct.
Okay. 12, furnish a defendant with books, papers, documents, etc. Obtained from his personal, again, we've already talked about that, I believe. 13, furnish the defendant any relevant evidence that's been provided to the state by an informant. Is there any such evidence that you're aware of that's not disclosed?
No, I believe actually this next section here is sort of a cut and paste repeat from earlier
Right.
numbers.
Right. Again, 14, I think we've dealt with before. 15, sculptory evidence we've talked about. 15, 16, we've already talked about that, evidence seized but not returned. And 17, written recorded statements. Again, we talked about that today and I believe earlier in the discovery motion. So we've gone through your demand for discovery and inspection, right?
Yeah, I have requested photos of the alleged lights that was,
I'm sorry, photos of what, please?
photographs of the alleged lights that was taken out of my storage unit. And when I got home and looked at the, put the disc in, the disc, it had a guy that I've never seen a day in my life, and some marijuana, and that he obviously got caught with on the highway. I don't even know, I don't even think he's from Racine. They took a picture of his ID, and he was from like Missouri or something like that. I believe the sheriffs pulled him over smuggling marijuana, and the disc was filled with stuff with his evidence. So I have requested copies to Dale. I picked it up. I requested I gave Deputy William Dale a specific list of all of the evidence that I was seeking. And when I got there, none of the evidence, except for like 2-3 pieces, it was 19 different pieces of discovery I had requested, and he gave it to me in like a sealed envelope like this. And I wanted to inspect the evidence before I purchased it, but the sheriff department forced me to purchase it first. And so when I purchased it and I opened it up, it was a bunch of stuff that I already had that I didn't request. And the majority of the evidence that I was looking for was in the envelope. So, but one of the discs that I thought was going to be the evidence that I was requesting was a video of, it was photos of some guy who got pulled over on the highway smuggling marijuana to Wisconsin. And that's what it was.
So what's the wrong evidence, you think?
It was the wrong evidence, obviously. It did have a few photos that pertained to me, that was specific to me, but majority of it was to whoever the guy was they pulled over on the highway.
So I'm not sure what their system is in terms of being able to make a video or a copy of a DVD with photos and so on. Any sense of why that might happen?
I'm not sure, I guess I'm not exactly sure what the defendant was requesting, if he wanted them to go out and take additional photographs of evidence, or if he was just asking for photographs that exist.
I think what he's saying is he got a disc, but on the disc was information that doesn't appear to relate to his case. And he just copied the wrong thing.
Also, I was given a search warrant that don't relate to my case. They gave me a search warrant to a attempted homicide case in Union Grove, Wisconsin.
Who gave that to you?
I was provided with it. It's a disc called Barker Disc 2 search warrants. Those blank search warrants that I gave you, that's where they made their original search warrant template disc. And Attorney Davis sat down and gave me that search warrant on, I believe August or September 2015.
So it didn't come from the sheriff's department, it came through your attorney, Mr. Saldana?
And he allegedly got it. Well, I got the correspondence email. He picked up the disc from Patricia Hanson on June 22nd, 2015, and he obviously printed the search warrants from the disc on June 22nd, 23rd, 2015, because.
But it had other stuff on it.
It had stuff on there, like for instance, the search warrant to
Some other man.
a murder case, yeah, to homicide case.
Maybe we can have somebody look into that and see what happened there, and why they would send in that. I'm not sure what the process is that they're able to isolate, but they copy onto a disk and not include other things. Maybe I'm not sure how that happens.
I'm not sure if the defendant wanted to provide me with a disc, and I could look into it and do that. I think without actually having the disc, I don't know that I'd be able to narrow it down.
You want to hand him the disc and he'll take a look at it and see what he can figure out?
I can give him a disc, but these are my, but I filed them already with the courts. I got the receipt right here to prove that I filed them. Here a receipt. It is signed by Deputy Clerk Jamie Harding on March 24th, 17. This is all the evidence that I took down there physically, and this is the proof of discovery receipt. It's titled, and it was filed by the clerk of courts, and they accepted all the documents that I was filing. And these red stars indicate out of these 39 documents, only 11 of the documents ever made it to records. The other documents was lost, destroyed, or whatever, but it never made it to records. You can keep that for your records. So they're tapping on my public records inside the clerk's office. So yeah, I filed I took physical copies of the CDs. It's all right there in that list right there. I took physical copies of everything, and it just disappeared. No receipt, nothing. But I do have. I'm going to give you. I will provide you with additional DVDs and also my revocation hearings. But these are my hard copies. These are my only copies right here, so I can't give you these. But I'll make copies for you. Would you accept it through email or send you a link where you can download it yourself? Because I filed them on CCAP that way for a downloadable link.
I don't think CCAP will do a downloadable link to a video, but if however you transfer them to me, as long as I can open them or access them, that's fine.
All right. So what's left here on the motions then? You say you want to present some evidence, some witnesses?
Yes.
To what, on what motion?
Basically today, like I wanted to cross-examine Yvonne McNeil. I would like to cross-examine Yvonne McNeil and Josh Golden and Attorney Jennifer Savino about the August 21st, 2015 issue. And about a few things that I would like to, and I also would like to cross-examine Investigator Vanderbilt, given that he is the lead investigation on this. I already subpoenaed him twice, and he didn't show up after being subpoenaed on November 23rd, 2015 and January 31st, 2016. So I would like to be able to have the opportunity to cross-examine him too. But first I need you to fill out the NC form.
So I will look for that, and if it's there, I'll review it and see, and then I'll approve it. And then we'll have you work through the clerk's office with respect to issuing subpoenas for people that you want to have testify, right?
Yeah.
So we'll need to set another date here for another motion hearing.
Yes.
Finish this, and at that motion hearing, I'd like to, since we're getting close to the trial, I'll start to talk about trial issues and the procedure for trial.
Right.
And some things you ought to start to think about is the process of trial begins with selecting a jury.
Right.
And in a jury selection, parties are able to ask questions of jurors about their qualifications to serve as jurors on the case. In light of the fact that we have a person who's not experienced, and to save us a lot of trouble with you being interrupted when you ask a question and so on, I'm going to have both sides write out the questions they'd like to ask on voir dire. We'll look at them next time we come here. What questions would you like to ask the jurors? We'll review them. I'm not sure whether I will let you ask the questions that you want to ask or whether I will ask all the questions of the jurors, which is commonly done. But we'll see once we have your questions. So write out questions in your handwriting or on your computer, whatever, that you would like to ask the jurors about their qualifications to serve in this case as a juror if they are selected, all right? And
I really object to that. I would like to look them in the eyes and ask them questions if that's possible.
but we'll see what you want to ask. It may be possible, I don't know, I haven't decided that yet, but it is possible that I might exercise my prerogative as a judge to ask questions that both sides want to have the jurors answer, okay? All right, but we'll talk about that next time, all right? So we'll give you another date here in another couple of weeks.
I also need that notary public name that he said he don't know that signed the warrant. He said he don't know the name. I would like to add her.
We'll ask the officer to go back to the department with a copy of that to see if he can have fellow investigators help him figure out whose signature that might be, okay? Give that name then to Mr. Wiedenfield, and we'll take it from there, okay?
One more question. Lewis, It's an investigator named Lewis. I just know Lewis. I don't even know his first name.
Jesse,
Jesse Lewis.
J-E-S-S.
Okay?
Do May 10th at 1:30. That's a Thursday.
Okay. May 10th at 1:30?
Could I go just a little bit further? Attorney Johnson from my office will be returning that week, and I anticipate she'll resume this case as the
Oh.
prosecutor.
A week or two?
Just a week after that. she'll be back.
Okay, we can do May 17th at 1:30.
I'm not sure we'll be back here in the same location. We'll see what's available for a location for a court hearing, but we'll see you then. We still have the date set for trial, which is June 6th at 9 o'clock in the morning to commence with jury selection, all right?
Isn't it supposed to be a pretrial conference, final pretrial conference?
We'll talk about that when we need one next time, okay?
So,
Right.
but the next hearing is going to be a motion.
Right. And we will be in touch with you about whether or not we approve the indigency form you filled out. And then if you are approving it, then we'll have the clerk's office help you with subpoenas in terms of getting them properly issued and out, okay?
Will I have, will it be done timely? Because I don't want to find out the day before, the court date, that, like you responded to my motion today. So, I'm saying, I need time. I'm not a fluent attorney, so it takes research. I got to do a lot of research, things like
We'll
that.
get them to you as soon as we find the form and I review it. If we can't find the form on your indigency in the file, they'll notify you to file another one, okay? And as soon as I have that, review it and decide, we'll let you know whether we're going to assist you in issuing the subpoenas or whether you'll have to do it on your own, okay?
Yep.
All right, so we'll see you then back in court on May 17th at 1:30 to continue the motion hearing. And then, that's the date, right?
Yes.
Okay, and then again, we have the June 6th, 9 a.m. trial date, okay?
The place for the hearing is actually going to be in Branch 8 courtroom, which is the lower level of the LEC.
Okay.
Across the street, the lower level. Thank you.
Yeah.